My name is Matthew Rimmer. My presentation today is on intellectual property and bioprinting, biomedical innovation and public health. As is always the case at QT, I would like to acknowledge the Turrbal and Yugara as the First Nations owners of the lands where QT now stands, and we pay their respects to their elders, laws, customs and creation spirits, and we recognise that these lands have always been places of teaching and research and learning. For the past several years, I have been a chief investigator in an ARC discovery project looking at intellectual property and 3D printing. One of the main outputs of this work has been the collection 3D Printing and Beyond, Intellectual Property and Regulation, edited by Danusha Mendez, Mark Lemley and myself, Matthew Rimmer. Since the publication of that work, I have been delving further into some subfields of 3D printing, including bioprinting. I've been using a mixture of methodologies to investigate this topic. So I've been conducting qualitative interviews with over 100 stakeholders, including Stephen Jones MP, who has been a very eloquent advocate of Wollongong becoming a regional hub for biomanufacturing. I've been engaged in data analysis of patent registers. I've been looking at landmark litigation in relation to intellectual property and 3D printing. I've been considering whether there is any need for law reform in light of the advent of 3D printing and additive manufacturing and bioprinting. I've been looking at the ways in which the legal system has been engaged in specialist regulation of different species of 3D printing and additive manufacturing. And I've also been considering larger questions of innovation, law and policy. Today, I'm going to just focus on patent law and bioprinting and give you a quick snapshot of some of the key issues in relation to patentable subject matter, patent landscapes, patent infringement and patent exceptions. To begin with, the patent system is really designed to deal with mechanical inventions. So it kind of really came into its own with the Industrial Revolution. The patent system has often found it difficult to adapt to new technologies. And in the past, there have been controversies about how the patent system deals with information technology, medical technology, and biotechnology. After a long period of expansion, superior courts around the world have sought to set in place some boundaries or limits on patentable subject matter. Most notably, the Supreme Court of the United States has sought to confine the boundaries of what patentable subject matter is available in the United States. So in the cases of Bilski, Alice, metabolite matter and mirror genetics, the Supreme Court of the United States tried to draw a stronger line between patentable inventions and works which belonged in the public domain because they were mere products of nature or intellectual information or scientific discoveries. So those precedents have been applied by lower courts in a range of different circumstances. And we've also seen some other superior courts like the High Court of Australia and the Supreme Court of Canada also circumscribe eligible subject matter for patent protection as well. How will this affect bioprinting? From one perspective, bioprinting is just a form of manufacturing and is at the heart of what is traditionally protected under patent law. Others suggest that there might be some issues for 3D printing and bioprinting in terms of patentability because of the reliance upon various forms of digital technology, raising some of the issues around the Alice case and the Bilski case. And perhaps there are also some issues in relation to applications of biotechnology, raising issues similar to the Myriad case. But it would seem that really there's only going to be those exceptional cases that might have problems in relation to patentability. If you look at the patent landscapes, some trends are very kind of evident. There have been large numbers of patents filed in relation to 3D printing and various different subsectors like bioprinting. Those filings are dominated by parties from the United States and the European Union, also from Japan and South Korea. Increasingly, applicants from China also being noticeable in terms of the patent filings. There's a preponderance of commercial filings in relation to patent applications. There are still a few public research institutions and universities who are filing patent applications. It is also kind of quite striking how very kind of significant patent thickets are being formed across various different sectors of 3D printing. And certainly that will raise questions in terms of patent examination, in terms of determining the validity of patents, ensuring that they are novel, inventive, and useful. But also there are questions there about priority and how patent offices determine questions about priority. As 3D printing has matured, there have been increasingly patent conflicts in this area. So there was a very significant dispute called the Clear Correct dispute over dental appliances that have been 3D printed that went up to the US Federal Circuit. There was a patent and trade secrets dispute between two metal 3D printing companies, Desktop Metal and Markforged, and that kind of ended in a stalemate. But in the last couple of months, there's been a really significant new set of bioprinting patent disputes between CellInk and Organova. So CellInk has brought an action in the federal court in Delaware in the United States, and in return, Organova has brought an action against CellInk in the federal court in Waco, Texas. Just to give you some quick details of these disputes, which are still at very early stages. CellInk was founded in 2016 and has been a rising star in 3D bioprinting. It wants to position itself as the world-leading bioconvergence company, and has said in its annual reports that it's highly dependent upon intellectual property protection to be able to pursue development, marketing, and sales without obstructing competition. On the 3rd of June 2021, CellInk made a legal complaint arguing that Organova's patents had infringed upon its own, as well as those of its acquired subsidiaries. It sought leave to file the complaint under a seal because of confidential information. According to media reports, CellInk has argued that a range of bioprinting patents are in violation of its patents. And it also refers to MatTech Corporation and Visicol subsidiaries, of which it has substantial biotechnology patent portfolios. CellInk has also filed a petition before the USPTO Patent Trial and Appeal Board to institute proceedings against the claims of a number of patents held by Organova. In return, Organova has filed its own legal action against CellInk, accusing it of infringing its bioprinting patents and a patent held by one of its licensed organizations, the University of Missouri, who is the original inventor. Organova contends that CellInk BioX has infringed 3 patents and BioX6 has infringed another patent. For its part, CellInk has questioned the accusations that it's contravening the patents of fellow 3D bioprinting firm Organova. It's too early at this stage to determine what will happen in terms of an adjudication of the claims of the competing parties, but perhaps it represents a sign of the growing maturity of the field of bioprinting, but also the kind of significant kind of competition and rivalry in that space as well. I just want to finish up by mentioning the operation of patent exceptions, as well as kind of protecting the interests of intellectual property owners. Patent law is designed to protect the larger public interest in relation to public health, access to knowledge and technology transfer. It has a number of different mechanisms that will help it achieve these goals. I guess given the past conflicts in relation to gene patents and access to essential medicines, it's well worth thinking about some of these exceptions. The defence of experimental use is very important, particularly for researchers, although it's very narrowly confined in the United States to pure research after the Duke versus Maddie decision. Other jurisdictions like Australia and the European Union have a much broader version of the defence of experimental use. There's been a lot of discussion about the need for public sector licensing of inventions, particularly when there was public funding in relation to those inventions. Moreover, there's been also a great deal of interest in terms of the sharing of research tools. So the National Institutes of Health has set up the 3D print exchange to help exchange models in relation to 3D printing and medical 3D printing and bioprinting. The mechanism of patent pools has also been used, particularly where there are very significant patent thickets in a sector or an industry, and there's a need for a mechanism to try to ensure that there can be access given to key patents. And we've certainly seen that in relation to access to essential medicines with the creation of the medicines patent pool. It's also worth remembering that governments retain powers to engage in compulsory licensing, Crown use and government acquisition to deal with situations where there is anti-competitive conduct, where there are competition concerns, but also to deal with kind of public health interest questions as well. The Honourable Michael Kirby, former Justice of the High Court of Australia, has talked about the need to make sure that such flexibilities are used to ensure that the wider public interest in the IP system is served. So interesting developments in relation to patent law and bioprinting in terms of patent subject matter, in terms of patent landscapes. There's some new emerging skirmishes in relation to patent infringement, and there are issues in relation to patent exceptions. It's also worthwhile to think about other secondary forms of intellectual property like trade secrets, copyright law, the operation of trademarks. Increasingly, there are also issues around the regulation of bioprinting as well. So the Food and Drug Administration in the United States has put in place new guidelines. There's been a law reform process in Australia dealing with customised, personalised medical devices with the Therapeutic Goods Act. And there are similar developments elsewhere in terms of the regulation of bioprinting. Anyway, thank you for your time and attention. And if you have any questions or queries, please don't hesitate to contact me. Thank you very much.